Good morning, all. Welcome to the webinar. And today's topic is use your lawyer to avoid litigation. And we have Advocate Nainan John, who is a corporate lawyer to High Court of Kerala, and associated with a legal firm named the Basil Matthew and Company. He has been advising companies since 19 plus years, and he is specialized in contract management, both in customer and vendor thing. And also, he is specialized in co-founder contract, employment contract, funding contract, and also helping companies in the IP valuations order. He has been associated with a lot of corporates, and he has a prior experience with a lot of corporates. And he's also mentor to Kerala Startup Mission and supported many startups for getting legal advices, and also supporting Kerala Startup Mission in its internal contract and legal wettings. So over to you, Advocate Nainan John, and we will be hosting this session, and in which he will be talking about nearly for 30 to 40 minutes, and after that we can have the question answer session. Over to you, Advocate Nainan John.
Thank you, Vishal. Thank you for the introduction. Friends, Corona has brought us a new experience altogether. I am talking to people, something which we used to do or for conference calls, but we never used to imagine to have seminars and webinars extensively for topics like this. But good, in a way it is good that world has shrunk into the box, and information dissemination is much easier and faster. So the way we have designed this session today is, as Vishal said, we'll have a introduction of the topic by me for some time, and then we'll have a very informal, open conversation. So when this topic, when Vishal spoke to me, and then this topic of how to use a lawyer to avoid litigation came up. Some people call me and ask, why do you want? Why? What is this logic behind this topic? Why did you name it this way? To tell you something, if you take say when I passed out and all those years, when we talk about lawyers and corporates, it is mostly lawyer for litigation. The lawyer is used by a corporate when they have a case of matter of litigation or a police complaint, something like that, and then the lawyer is used only for litigation. So I probably think it is in late 90s or early 2000 that the concept radically changed, where companies, especially the IT companies, started thinking that we should use a lawyer not only to litigate, but also to avoid litigation. So how do you avoid litigation? So if you look at any corporate, I presume most of you are from having either on a managerial role or an entrepreneur. If you look at any corporate, the litigation possibilities, keeping away the government and the statutory bodies, the litigation possibilities are generally from the close stakeholders, not from, unless it is generally from close stakeholders. And so who are the stakeholders? The litigation possibilities is what I'm talking about. Who are the stakeholders? It's the customer. First of all, the customer. Then you have your vendors, your suppliers. Then you have your employees. Then you have your co-founders, your promoters or shareholders, whoever it is. See, these are the people with whom you are closely interacting when you run an organization. And it is from these set of people that we have a potential risk of a claim or a dispute or a difference of opinion. So it is very important to have the documentation perfectly done with these stakeholders. So when you say documentation with these stakeholders, it is nothing but a contract, because it is a commercial transaction that is going between the stakeholders. So you need to have a contract which clearly lays down the roles and responsibilities of each party, so that there is no confusion tomorrow. So how you draft a contract where you where you define the terms of responsibility. This is what I'm going to do. This is what you're going to do. This is what you're going to get. This is what I'm going to get. Okay, and how long is this? It's a simple mechanism. Let's not think about too much legal into it. It's a simple mechanism of clearly saying who will do what and when. That's all. So when you have a contract perfectly laying down the terms of relationship, then the possibility of litigation comes down. So that is when in early 2000s, companies started extensively using lawyers for each and every contract, and the in-house lawyer concept or the in-house counsel concept became very prevalent in early 2000 onwards. Till then, lawyers were only finding jobs in litigating firms, like either a litigating law firm or he will start his own office for litigation and then support companies on transactional matters. But a concept of in-house legal counsels came into picture late 90s and early 2000s. So that was a radical change. Now, before getting into the topic, or I would like to present the topic in a different way. I don't want to make it too complex or too, mundane. Probably I want to share some stories with you. So I, particularly use the word story because I don't want to call this incidents. I don't want you to come back and ask me the details of it. So that's why I'm calling it, deliberately calling it stories. So I'll share some stories. First is a story of a company who wanted to engage with a customer of that company. This company is a software company. Okay, so this is a software services company. So software services company, there are two types of software services. Generally, a fixed price contract where there is a scope defined and a price defined, and then you perform the services based on the fixed price. It's like you engaging a contractor for a turnkey contractor, right? You want to make your house and then you build your house and then you engage a contractor end to end. So and you fix the scope, you fix the design, you fix the drawings, and then you give the timelines and you give the money also based on milestones. So that's a fixed price contract. And then you can also engage a contractor only for labor supply. You get people, that it is your design. You get people, they will fix the doors, they will fix the the windows, the masonry work, everything is done by a contractor who will supply people for you, who will work as per your direction, or probably he must give you a supervisor. So this is the way in which projects are done. So the one is called T&M and one is called fixed price. So this company was doing a fixed T&M project, which is a monthly billing. It's a monthly billing. At the end of the month, the company raised the bill, and then the project, the amount is being paid. So then they negotiated this contract. It was done by company to company without any legal help. Now, when they negotiated this contract, the other party the customer added a clause called acceptance of deliverable. So acceptance of deliverable seems good. Okay, fine. When I give you something, it should be acceptable to you. So acceptance of deliverable was added as a clause. So the client company, the supplier company started invoicing, and then they were paid also. After some time, the issue started coming up between these two. Now the client company came back and said, see, your deliverables are not passing through acceptance. So you are not eligible for that money that we have paid. So then this company said, so no, first of all, there should not be any acceptance. Second at all, what you are saying as acceptance, not passing through acceptance, is not the critical L1 issues or L2 issues. It's basically cosmetic changes, or rather more of a change of scope. Like, it is not the scope that you have asked us to do. It is more of a new scope that you're talking about. It's not at all an acceptance. It's not a bug, or it's not a issue with what I have given you, because even the requirement specification is given at that point of time, right? So the supplier company do not have any role in that. So they said, see, this is more of change request, change of scope. So I have nothing to do. But there was a contract which spoke about payment monthly, but which also spoke about acceptance in a detailed manner. So then that became an issue. Second story I want to share you is a company it's a company who is developing a product for themselves. So a particular module of the product they wanted to outsource for development. So they identified a company, they spoke to multiple companies, they identified a particular company, they were happy with that company's expertise, their everything, and then finalized the deal. Scope was given to them. Clear commercials were agreed that you give this and this is the money and this is how we are going to pay. Everything was agreed, pakka in black and white, and only they did the contract, and then the deal was done. Now they delivered on time. What they delivered was nice, good, and the client company started using it in their product. After some time, the client company started becoming popular and picking up momentum. This supplier company came back and said, "See, we have given you some code or software of ourselves, which ideally is ours, and we see that you are using it as yours. We gave you a license. We did not give you a product. The IP belongs to us, not to you." So they went back immediately. When you have a problem, you immediately pull out the contract. So they went to the contract, and the contract doesn't talk about any of these things. The contract talks about scope, requirement specifications, and the deliverables, timeline of delivery. That's it. Payment, things like that. That's it. It doesn't talk about ownership of deliverables. That became an issue, and that's a major issue. So then they said, "See, we have paid you. We paid you because we wanted the IP." They said, "No, you paid me because you wanted the license, not the IP." So that became an issue. The third thing is about an employee. So this company, this is another incident. Okay, let's call it story. This company had an employee in the sales team, and this sales person was interacting with a lot of customers across Kerala. So finally, at one point of time, they identified that this person has some problem. His performance dipped and things like that. So then they did some background verification and found that he's having a contact with one of the competitors. So they called me and said, "See, we have a problem like this." I said, "So that's okay. What can we do? We can't stop people from talking to others, but you be careful about him. I hope you have an NDA and all signed with him." They said, "We'll check and see if not an NDA is signed, we'll have an NDA signed." I said, "Make sure that there's an NDA signed pre-dated." So they signed, somehow made him sign an NDA and things like that. Finally, he left the company. He left the company and joined a competitor, not too late. That was okay for this company, even though there was a non-compete clause in the contract, in the employment. I'm not getting into the enforceability of a non-compete clause. Even though there was a non-compete clause, they were still okay with him joining a competitor, but he started poaching into this company's customers, even existing customers. That became a problem, especially to manage the existing sales team of the company, because this gives wrong signals in the company. Now the company came to me and I said, "Just check whether his emails and past history, he could have done something, and they could find something where he had actually taken out some information from the company, some personal information from the company." That was enough. So we sent him a legal notice and all, but at the same time, filed a police complaint, because that became a criminal offense. Filed a police complaint. And this person, incidentally, was related to a policeman also. But to tell you something, this matter was settled. This boy came to the police station. Finally, he had to resign from the other company, tender an unconditional apology to the previous company, and then he admitted his wrongdoings in the letter, and then he resigned from the other company, because the other company also washed their hands off at that point of time. Okay, that was possible because they had a very good NDA at that point of time with the employee. Fourth story is about another company where three friends came together and started a company. So they had very clear understanding. Okay, I am going to be the MD, CEO, and MD and CEO. I will run the sales team also. I have the sales responsibility. So generic strategy and all, I have the responsibility. You will do you have more of a technology background. So he will do the technology part. So there is an X person share for me, Y person share for him, and third person who is an operational person. So he will have Z person shares. Now that was agreed, understood, and formed the company. Three promoters, like three of us, formed the company and started running the company. We had put in some money from our savings, We're running, we are not taking any money out of this. We're employees. We are reasonably going okay. At the end of second year, this operational person came back and said, see, guys, I got a job in Middle East. This is not going anywhere. I don't see too much of light at the end of the tunnel. Okay, I'm calling it off. So they were a bit setback, and then say, okay, fine, it's your personal call. We can't stop you from doing it. We are okay with you going, but please transfer the shares to us. And he said, see, that is not possible because shares belong to me. I have those ownership over the shares. So why should I give it to you? So then they said, see, we gave you the shares. The company gave you the shares, hoping that you're going to be with the company. Otherwise, company wouldn't have given you the shares. We expected you to be in the journey together, not to offboard in between. That's what you're doing. He said, no. You've paid me hoping that I'm going to be with you for 2 years. I have been here for 2 years. And this is my compensation for those 2 years hard work. I have put in hard work, a lot of hard work. This is my compensation, my remuneration for those 2 years. You can imagine how when a partner moves out with a chunk of shares, and then you have big plans for going for future, capital infusement with venture capitalists or angels. You know how it looks when now a third party has taken some significant chunk of shares. That becomes a big problem. So these 4 stories are just food for thought for you. I want you to think about these stories. Probably you can also find out, where it went wrong, how better it could have been handled, what should have been done. Just think about those 4 stories. Okay? While we move on. See, the problem that generally happens is, people think that a contract can be used, if it is used here, it can be used there also. Okay, that's a general misunderstanding. It is not that the shirt fits for everyone. Okay, you probably may have a contract which you have used which your client has given you, and you use that contract for yourself. And the next client comes, it's a client's template. Your client has given you negotiated that, and then you signed it. And then the next client walks in. You take this, change the client's name, change the figures, change the scope, and give it to the other client as your template. Say, see, this is the contract I want to sign. And the other client might sign it with some negotiation. But let me tell you, the contract that fits one person doesn't fit another person. You can have templates. There is something called a perspective of a contract. You know what a perspective of contract is? Like, one of you come to me and say, see, I have a client, and I want to have a contract with them. So the first thing that I ask you is, okay, fine. So you are supplying something to the client. So what are you supplying? What is your business? How do you do? How do you deliver? What is the scope? And when is the payment? How is the payment secured? When will you be able to raise in your invoice? How will you be paid? What is the credit period? I ask you a lot of questions. And then I also may ask you, like, not me, any lawyer whom you approach may ask you, what could be the risk? What is the risk that you perceive or foresee in this? See, basically, what the lawyer is trying to do is actually put himself into your shoes and see the relation and then see where it can go wrong. The lawyer is trying to see all the possibilities where it can really go wrong. That's why he is asking you those questions. So trying to understand your business and where it can go wrong. Okay. Now he drafts a contract for you. That is from your perspective. Now the client gets that. Okay. Client sees, it may look very neutral and all. Okay. It may look because you will, no good lawyer will give you a very unbiased contract because the client will not be happy or the supplier will not be happy. So it may look very neutral, but underlying it is written from your perspective. Okay. Now the client takes that and uses it with his next supplier. What he misses to understand is that it is written by a lawyer from the perspective of a supplier, not from the perspective of a client, which is not good for you. So always remember, there is a perspective of a contract. Simple manner of copying and pasting it or using it in a different manner doesn't always help you. Okay, it's not that it will land you in trouble. It doesn't always help you. In a contract, you should understand the perspective. Okay, with that we should think, what is there in a contract? You talk about a lot of contracts. There are multiple number of contracts, and there are multiple number of sites where you can download contracts. Okay, for small amount of money you can download contracts. But what is there in a contract? If you look at a contract, there are three major, whether any contract you take, any commercial contract, there are three major aspects. One is the operational part. What is it that I'm giving? What is it? What is the scope of work? So, for example, if it is I'm getting my house built, okay, I'm getting my house built. So I engage a contractor and I ask him and I tell him, see, this is the scope, this is the drawing, this is the specification of the big BOQ, this is specification of the material that has to be used, this is the design, and this is how you have to, timeline of delivery is this, and then so this is the overall scope. Then what is the next part? Then you talk about the commercials. So how much is it? The how much? How is it paid? When is it paid? When can you raise your invoice? Is it when you complete your basement level? How much is it when you put your when you go up to the lintel level? When you have the first floor RCC being cast? When you have the plastering being done? When you have the interiors being done? So there are milestone-based payments. Okay, and what is the tax involved in it? What is a credit period? Things like that. So that's a commercial. So you have operations, you have commercial part, and then you have a legal part also. Okay, a pakka legal part. Say for example, it may talk about the warranties given, it may talk about the indemnities given, it may talk about the liabilities part, a lot of stuff. Okay. Now, when you have a contract, if you remember the client contract, the outsourced development contract that we spoke about, it was pakka when it came to commercial, operational part and the commercial part. When it came to the legal part, there was a problem. But just having the legal clauses pakka doesn't mean that you will have a good contract. You will have a good contract, but the contract may not help you in need. I'll give you an example. Like you have agreed for certain operational conditions in the contract. And it is the management who or the senior person who have negotiated the contract. It's a well negotiated contract, balanced contract, not too harming for your interest, and you've signed the contract. Now you gave the project to the operation team for delivery. Now there is this junior level PM who is handling it. He is not really bothered about the intricacies of the contract, or he might not even understand the intricacies of the contract. Now there is let's take an example of a software company. There is a delivery which is being planned. So the delivery, in one of the conference calls, the client's PM said, see guys, this particular functionality will move to the next release, or probably I want it this way, not that way. And if this is not recorded, and you have a conference call which goes as a conference call and no minutes of meeting circulated, unlike in Agile and things like that. But generally, it goes unrecorded, unminuted, or not even amendment, nothing, not even an email on this. When something goes wrong, you know what the lawyers do? The lawyers' first thing that they do is actually to pull out the delivery and see where has it gone wrong. First, the lawyer will actually try to see where all the other party has breached the terms of the contract. That's the first thing that they do everywhere. So if you have breached the contract, not delivering on time is a breach. Delivering it in a different way is a breach. And if you can't, probably you did it because they asked you to do it, but you're not able to prove. At that point, you're not able to prove. or the person who did it has already left and joined another company. There is no mail trail. Your sysadmin has deleted all his mail trails. You do not have anything to prove. So, though you have a pakka legal contract as a excellent legal clauses, commercial clauses, and operational clauses also, but on a management of operations you messed up, then you have a problem. So it is when we talk about contracts, it is not only about having a well negotiated contract. It is only also about managing the contract delivery part. Like when you have a operation side of the contract is also very important when it comes to compliance. Now that I before I get into the the question and session, I just also want to tell you about something called an NDA, which I actually mentioned about an employee NDA some time back. So we cannot have a 1 hour session to talk at length about all the contracts, right? No? So there are multiple types of contracts that I say. But NDA is a very important contract, especially for companies who want to keep things confidential. Okay. Now employees definitely they get into an NDA, but with customers also, suppliers you can push your NDA, but with customers also you need to have an NDA, especially if you have your own IP, something which you want to protect. Now, when can you push that? You can't just go and ask the customer before you start talking. You can't just ask the customer to sign an NDA. They may not be happy to do that. So you need to have an internal system where okay, fine. With customers, I will share this much of information without an NDA, which is publicly available. I'll generate his interest and then get into even a demo. Some people do it without an NDA. It's all to generate interest. But the company has an internal decision where they take, okay, fine, it is up to this level that we will share information without an NDA. At this level, we will insist on NDA. Whether it's his NDA or our NDA, it doesn't really matter. What matters is whether my information is protected. Okay. Now, even with an NDA, how much can I divulge? Because he's not still a customer. He's still a prospective customer. So how much do I divulge? That is again a management call. That's again a call that the company takes, and that should be that understanding should be there for everyone. Every customer facing person should know how much he can share, even with an NDA. Now he becomes a customer. At that point of time, also you should know how much you can share and how much you can't share. Okay, because not all the IP holding companies that they don't share every information, every algorithm, every concept. They share only the usage part with the customer. Okay, so that's one thing that you need to keep in mind when it comes to NDA. Friends, I think it's almost 30 plus minutes, 35 minutes, but keep in mind there are two types of entrepreneurs that I have seen always. One set of entrepreneurs or one set of companies, they are ready and eager to sign on a dotted line. I really don't care. Where is that contract? Where is the dotted line? I'll sign. I'll take the risk. It doesn't really matter to me. How much is the money is what he's bothered about. Okay? And when will I get the money? He's a pakka businessman. I really only concerned about the money. There is another set of entrepreneurs where they are too finicky. Like they want the best of the best contract, best of the best clauses, worst of the worst clauses for them. They want it to be too restrictive. They want it to be go this way. They will not allow this to happen, that to happen. They will start Googling about all sort of possibilities, and then they will make your agreement as pakka as possible. I would say that both are not good. Vishal, I think there is a post in there that somebody can't hear. Is that was it mostly a silent movie, or were you able to hear me?
I think no other issues has been.
Okay, great. Let's move forward. So the point here is that it is this kind of an approach is also not right, and this kind of approach is not also right. See, as a management, as an entrepreneur, or as a senior people, what you need to think is you need to understand the risks that you're taking in a contract, in a commercial deal. You need to know what you're taking. You need to understand, once you understand the risk, you need to look at the risk mitigation plan, or how much it's going to affect you, or what is your plan to mitigate that risk. Can I actually chew that risk? Is it okay for me to bite it? That's a management call, not a lawyer's call. Never ever leave those calls to the lawyer. The lawyer will always try to put the best case scenario for you, because he wants to protect your interest, and his lawyer also would always want to protect his client's interest, because he wants the client to be safe. So he will always put up the best case scenario for you. He may give you options, but the call is yours. Never leave the call to the lawyer. You should listen to the lawyer, and it is a business call. Ultimately, you understand the situation, you assess the situation, you take guidance, but it is your management call. And at some point of time, I have seen cases when we actually negotiate, certain clauses, lawyer to lawyer negotiation can become very dirty, because everybody is trying to prove a point before others. But business to business negotiation may not be as dirty as lawyer to lawyer negotiation. So business has an interest to move on. So certain point of time, you need to have a business to business talk where you convince the other person about your problem, and then say that, okay, this is why I'm asking this. How can we solve the problem? Okay, so that is how you should take the negotiation forward, rather than having a tough negotiation on clauses and then getting into straining your relationship even before your commercial association has started. So you should play it very safe, where you handle it in a better way. Where you're not just ready to sign on the dotted line, but at the same time you should ask for what is genuinely reasonable for you, and then move forward. Okay, so coming back to the point that we started, the why I chose a topic like this, use your lawyer to avoid litigation. I hope you are somewhat clear that it's a good contract where the terms are clear. There is not much of ambiguity, and when there's not much of ambiguity, people may not think about raising an issue because they know that they have already accepted it. Okay, once they know that, okay, fine, I have already accepted it, it's fine. Let's not get into an issue. Let's move forward. Is the general approach. Okay, but then there's an ambiguity. Then people will start interpreting in this way and that way. Okay, that becomes an issue. Now, when it is a good contract, it doesn't mean that you will not have litigation at all. You will still may have litigation, because that is not in your hands. It is in somebody else's hand. You may want to initiate litigation. He may want to initiate litigation against you. But the point there is, when there is an inevitable litigation coming to you, or you initiating a litigation, you should have a contract clauses which is relatively substantial enough to defend yourself, or to be slightly offensive, so that you both come to a negotiation table and settle the matter. You got what I'm saying? So your contract should be strong enough for you to have to even, there's a concept called litigating to settle. Because not every litigation is supposed to drag for years and then get into a final decree. Companies may not prefer doing that. They start litigation just to settle, because that is the only way you bring people to a negotiation table. You talk to them and then settle it out. So, but even then, for you to do that, you need to have good defense, so that the other party feels that, okay, fine, it's better for me also to settle it out. You got what I'm saying? So that's the conclusion of the whole thing. The most difficult part, let me tell you, my friends, is in a webinar, is that you don't see anyone except for the thumbs up, and luckily I have not seen thumbs down, but that's only, it's completely non-personally. I don't see faces, I don't see changes in the faces, I don't get a reaction back. But I hope you understood what I was trying to tell you. Probably, Vishal, we can open the floor for a discussion. You can decide how you want to run that question and answer session.
Thank you for the session. Now it's time for question answers, and there is a couple of questions in the questions box.
Yeah.
So Mr. Ranjit Paul is asking, how should an agreement or an NDA can be executed? Can it be a signed and a scanned copy, or do we need a physical stamp paper, signed or electronic sign, etc.? Adding to that question, Srisham is also asking, can we sign the NDA through mail now? So that is the first question.
Okay, so we'll talk about this NDA, or let's take any contract. So this is a question, Ranjit and Srisham, that generally most of the companies raise now, because everybody would want to have the contracting, the signing process simplified, especially because earlier we used to do it across districts or across states. Now it is generally international, and it's not really possible to send a document across and then have it signed. But let me tell you, when within India, when you have a document accepted, if you need to produce a document before a court of law as an evidence, the law in India actually stipulates certain things, that this is how you can produce it. These documents can be accepted. So in that, if it is an agreement, there is something called a Stamp Act, there's something called a Registration Act, and things like that. Now, these commercial contracts need not be registered, but probably they may have to be stamped. Now, the point what generally happens is that the signature may be an emailed signature, or what you call this is DocuSign or something like that, which is okay till things are fair. Now, when things go out of hand, it goes to a lawyer. When it comes to a litigating lawyer, and if the contract is not in favor of his client, the first thing that he would say is, who signed this contract? We have not signed this. Or what we have signed is not this document. Some people come and ask me whether you can have a I agree button, and you have pressed the I agree button, and is that not enough? Everybody is doing that. I said that is enough as long as the other person says that this is not what I pressed. So ideally, it should be a physically signed document. Ideally, but certain cases, but you take a call at some point of time. Like I'll give you another example. Like you need to assess the risk at that point of time. Sometimes it could be an NDA. An NDA, you are not sharing too much of information. You know that, and it is for their sharing too much of information. And accepting an NDA, online and signing it and scanning it, that's okay, because you're not anyway going to, breach the contract. So you know that. But if you're, disclosing too much of your information, and it is just a signed document over the web, then you need to be a bit careful. It is like, if I have a product and I am giving that license to a product on an on-premises mode, where I am loading it in his server, or compared to I am loading it in my AWS server and giving him a hosted services or a SaaS model, then I have better control over the product, my product. When it's a SaaS model, I have better control. So the contracting also can be a bit lenient at that point of time. I hope I make myself clear on that. So you cannot have a blanket answer to that, but it depends on the situation. But if you're asking a question whether an NDA can be signed online, can be signed, because a contract can even be oral. An acceptance can even be oral. But the problem when it is when the other party denies that oral or that email signature and says that it is not my signature, it's not whom I have signed. I mean, it is not me who have signed it. We have not accepted these terms. What's the next question?
Next question is, as a startup, how will we be able to manage, and can we have a say in the applicable law and jurisdiction, especially if the client is established?
Established outside is what he meant, I think. I I don't think you have too much of say. These are stages where you actually look at the dotted lines and sign. I know that sometimes it is inevitable, because you need to have your company running for you rather than having a contract which is well negotiated. Because most of the cases, jurisdiction becomes a big problem. Generally, it is enforced by, there is a power of balance on negotiation, right? There is a power of balance. So when you're negotiating as a client, it is extremely different when you're negotiating with with a supplier. But even the supplier is too big. Say, for example, you're negotiating with Oracle or you're negotiating with Microsoft, then or AWS. Your supplier is too big that even though we are paying him, it becomes very difficult for us to enforce certain things. We have seen that happening in the COVID situation with the government also. Right? The government actually accepted some other jurisdiction because they said they're giving it free. So it may not be really possible. We signed a contract with the vendor to develop a part of our software. Out of agreed 6 lakhs, we gave 4 lakhs. They demanded balance amount. We could not get the software till now. Should we file a case? We have signed an NDA and a contract with the vendor to develop a part of our software. Agreed 6 lakhs and we gave 4 lakhs. Should we file a case is a management decision. You ask a lawyer, should we file a case? The lawyer will always say, you should file a case and get that money back if you are not happy with what you've got. But it is a management decision coupled with what evidence you have, how strong your case is. So if you're not even able to get that 4 lakhs back, you should try to save that 2 lakhs. Okay, and why waste good money over bad money again? So that is a call that you need to take depending on the map. But ultimately, it's a commonsensical question. Why should I pay someone who is not delivering what he's supposed to give me? Again, here the problem is that I am not sure whether the other person has been happy with the answer, my explanation. We'll move forward, Vishal, on the next point.
Yeah, next question is like, are there any courses on contract management?
Are there any courses on contract management? I don't know, actually. To tell you frankly, I really don't know. Let me put my opinion on that. It's not the answer. There is no course on these things. This is pakka common sense. There is a reason why we are doing everything in when it comes to contracts, right? So you should think it from a simple commonsensical point of view. A simple commonsensical point is that when a person is being authorized by you to run a project under a particular contract, and if he doesn't know what the contract he need not know the commercials, but at least he should know what his obligations are. And if you are not giving him, then what's the point in complaining? So it is more of a commonsensical approach. There definitely could be courses on contract management, but I am not able to answer your question. How do we deal with contracts with respect to work from home when small companies cannot maintain that level of data security when people take codes back? Okay, so this actually brings, contracts cannot help you entirely. Okay, so for example, that is what I said. You can have an NDA obligating somebody not to divulge your information, but still you are divulging information, and it is for him, irrespective of the contract, to decide whether I should divulge. He may divulge it deliberately or he may divulge it unknowingly. So it is for you to decide what to give. Similarly, even if you have a contract with employees or anyone, or even if you've given your IP as a licensed product to a customer with a foolproof contract where you've clearly written down do's and don'ts, but still there is a technical loop in it where he is able to circumvent the timestamp on it. What's the point? He still will use it, and then you will be busy litigating with him, and he will be happily using it. So irrespective of all the contracts, it is like, you have police, you have a good legal system to take action against the offenders. But if you keep your doors open and still complain about theft, what's the point? So you need to have your housekeeping clean.
So next question is like, kindly explain how a project and a contract is interrelated. So before that, there was a question. It was already answered by you.
We didn't pay the balance since they did not.
Continuation that 6 lakhs question.
Yeah, but on the SKP business chief's question, see, there also you need to be careful about you. By not paying, you should not be breaching the contract, because you have not asserted the point that you are not paying because they have breached the contract. So ultimately, it will look like they delivered something which we do not know what it is, but you didn't pay. And they may come back and say, "We delivered, sir, and these guys did not pay." So ultimately, you have breached the contract. So that is just by not giving money, you don't think that you're safe. Kindly explain how a project and a contract is interrelated. That actually puts me in a difficult situation, because it's like, at the end of Ramayana, I need to explain how Rama is related to Sita. That I really didn't understand that question. Can we move forward on the next question?
Yeah, next question, like employees leaving company also sometime without notice, and KT abscond and later in few months charge about release, putting pressure how to be legally more robust in our contracts. Also,
Vishal, 1 second. Can others also see this question?
yes.
Employees leaving the company also sometimes without notice, and KT abscond and later few months charge about release, putting pressure how to be legally more robust in our contracts. Also, they poach and affect other employees leaving the company. These are two different questions, I think. A lot of confusion. Okay, yeah, the other question is a different question. So, employees leaving the company, you need to have a process for that. Okay, so when it comes to employee, it's a very important stakeholder for your company. So, your HR should have a process where you address the system of the problems of absconding cases. Exit is a very clear process, like entry. So, what documents they have signed. Probably even confirmation after probation is also very important, because if the employee continues to be in probation, at some point of time it may work good for you. So confirming him as at the end of a probation period there should be a document, and the employment letter also should clearly say that. So absconding cases, they poaching into your employees and all. If you have clauses in your contract, then you can actually initiate action against them. But something which you need to keep in mind is that there are two types of action. One is a civil action and a criminal action. So, remember the story that I told you. The employee left the company and joined a competitor, irrespective of the clause in the contract, employment contract, that he's not supposed to join the competitor. And they have identified competitors also. They went to a reasonable level of identifying. But he still joined that. Now, does that become a criminal offense? No. That is a civil offense. He has done something wrong, and that's a civil offense, and your remedy is only a civil remedy. Now, but if he has taken information from you, and that too personal information, so that there is a particular clause in the section in the Act, and then he has used it, then that becomes a criminal offense. These are two different things. So not always he will do a criminal thing, but even civil offense, it is difficult for him to manage a litigation. So you may start a litigation against an employee to not only to see that he is, justice is brought to you, but also to send a message to others. But at the same time, this is a double-edged sword. I will not always advise to litigate with employees, just for the fact that you should not be sending a wrong message in the job market, that this company is a company who chases people whom they leave, if they leave the company. So the PR, that is something which you need to manage. So how you make this information go down the grapevine is very important for you. I hope I was clear on that explanation.
So moving to next question, what is the process of MSMEs/startups to take action against clients who default payment for works delivered?
The process of MSME startups to take action against clients who default payments of work delivered. Okay, so it's whether it is startup or a not a startup, it's the same. I don't think there is any specific law for startup, to best of my knowledge. But when there is a default in payment, the only option for you is actually to take, send notice and take litigation. Start legal actions. But the problem for you could be if the person is in India, or if the person is in within vicinity, at least in Kerala, then it is easy to start a litigation mode. But it is extremely difficult. The person is in China or in US or Australia, where you even if you have an office there, it becomes unimaginably obscenely expensive for you to start a litigation there. So most of the companies, small companies, they actually give up on the money than spending on 4 times on the lawyer when you are not sure about the outcome. Okay, but if these people have a office here, then it is easy. If they have a revenue stream here, you can still attach it and then do something about it. Okay, so for your answer, there is no process. The process is the same. You need to start litigation activities against these people, but it becomes difficult if they are out of our jurisdiction.
So next question, if any breach occurs even after resigning from current job, the data security conditions were mentioned for 5 years even after if the employee, with thus the data security conditions he accepted in the NDA even after quit.
If the breach occurs after resigning the current job, the data security. Okay, so I think what he meant is that the NDA actually had a term of 5 years post the expiry of the contract, is what I interpret from his question. And the breach actually happened after he left, not while he was an employee. I hope this is what he's meant. So Prashant, that is still a breach because the contract actually obliges him to keep it confidential even after the exit from the company. So it doesn't really matter that he breached after, from after the exit from the company. You still be able to do, take action against him. But the problem, on a practical sense, is that the police actually do not understand most of these things. With all due respects, it's very difficult for us, but things have changed a lot compared to what it was in 2000 and all. Now it is extremely good because last week also we had a matter with the police. One of the clients had an issue. Police was so receptive, and they, the cyber police is really able to understand the nuances and take it forward. So to answer to your question, it is possible to take action if your contract is clear on that. How to deal with the ex-founder who refuses to give back the shares or blackmail later for large amount of money, etc. Wish not to spoil the relationship, neither must pay that was as he left. It is a difficult point. Unless you have, because shares is something which you have already given. And even if you have a co-founder agreement, you can only have some restriction on the, you can only have a dirty litigation with them than a straightforward move when it comes to taking back shares. Okay, you are forcing somebody to return it. So the best possible method, okay, or the next best possible method, I'll put it that way. You cannot have a foolproof method, but the next best possible method for this is actually to have a co-founder agreement when you start your company. Don't wait for a VC to come for you to have an SHA, where VC dictates the terms. You should, among yourself, have a co-founder agreement, a simple co-founder agreement saying that this is your duty, this is my duty, this is my duty, and this is the shares given. And if I leave, then I will give. There should be a tapering down model, some model that you work on. You should have an understanding how you're going to handle the share part if people are going. If you talk it clearly in the beginning, most of the problems can be avoided. These dirty things have to be discussed at the beginning, not at the end.
So here, 6 more questions are there. So can we have more questions, or we can stop by the 6 questions?
We will take some more questions and then move forward.
Okay.
Which is the next question? How to do?
It will be great if you can just brief about telemedicine legal issues.
Let me confess, I have no idea about it. I really don't. I didn't get the question fully. Telemedicine legal issue is something which I must also accept that I am not too sure about what you really meant. Probably, um, um, probably we can take it offline and then see what it is.
So the next question is like, for a strategic alliance with a New Zealand company, what should be an ideal jurisdiction clause? One, laws of the country of suffering party. Second, International Chamber of Commerce of Singapore. Third, laws of Singapore.
See, every legal system is, if you take Indian legal system, it itself is really complicated. No lawyer in India knows everything about. I think the best of the best lawyer would know maybe some portion of the Indian legal system. That's how it is. Now, to understand every legal system in the world itself is, for understanding our own legal system is difficult. So, understanding the entire legal system is difficult. But Singapore as a country, so I am not able to give you a straightforward answer on that. But Singapore as a country is very friendly on commercial terms, and they have a better system on when it comes to arbitration and mediation and arbitration. But please understand, it is not about the place of arbitration alone. It is also, suppose you get an award, okay, in favor of you. The party is in New Zealand, you are here in India. You have an arbitration clause in the contract that you will have arbitration done in Singapore. You really spend money, get the arbitration award in Singapore in your favor. You still, if they don't oblige with the arbitration award, you still will have to go and enforce that award. How do you do that? You can't do it in India. You can't do it in Singapore. You have to go to New Zealand in a court and then have it enforced. So there is a process involved in that. So, but the best part is that, and instead of doing it in New Zealand, or the actual commercial decision litigation, you manage to do it in Singapore, which is also good. But generally, most of the companies, most of the good companies, they honor awards given by arbitrators. So it may not be too difficult to enforce. Generally, Singapore is good place for as a neutral place for arbitration.
Next question is like,
You're a startup.
What all employee benefits should be provided for a permanent and temporary employee?
Okay, so Srisham, there are when you come to a company compliance. Okay, so now this discussion we were limiting it to the contracting part. So I was, when I was talking to Vishal also, I said that the company's need is not only contracting. There's a compliance part which is actually has a larger role. The compliance when it comes to the secretarial compliance and the tax compliance and the labor compliance. Okay, so labor compliance is extremely important. When you need to have, if you're a company with reasonably good size, it is always good to have a labor consultant supporting you on all your labor compliance matters. Okay.
Next question. A mutually signed, stamped, and scanned copy of the contract is valid? Or
A mutually signed, stamped. So I think stamped means the seal is what you meant. But in legal parlance, stamped means the non-judicial stamp paper that we have. Okay, so that's what you call a stamp. So a mutually stamped, signed, and the scanned copy of the contract. If you want, is valid, but if you want to produce it as an evidence before a court, you actually need the original. You actually need to show the properly stamped, not the stamp, but the stamped document. The problem starts when the other party denies it And second is to produce it as an evidence before the court. Can action be taken against people, or clause can be put for social media defamation by an ex-employee, as we notice that as an entertainment by few too without evidence of such claims. Defamation, whether it is in social media or in print media, is always a defamation. As long as you can prove that this person has defamed you, then you should be able to start action against it. We are a SaaS company. What is your suggestion to keep our terms of service healthy and protective? We are planning to launch it for global consumption. So, see, when you say you're a SaaS company, what I understood is that you have a product, IP of which remains with you, and then you are giving it on a cloud server for others to use on a subscription, some kind of a model of commercial model. Now, there you want to make it clear that it is very important for you to make it clear that the IP belongs to you, and they are only given a right to access and use it. Okay, so your terms of use. There also, it depends on how you want to have it. Most of companies still have the habit of having it signed, the hosting agreement. The terms of use should be clear on what you do, how much your uptime is, what is you're not promising 24/7, or if you're promising 24/7, what is the percentage of downtime permitted, or whatever it is, your SLAs generally. So your terms should be very clear, and you also should be able to bring out all the riders, like dependencies, I would say, because you can't give a warranty on waste for AWS. AWS server is down. If server is down, you can't do anything about it. So whatever dependencies, riders that you want to create, you should also create.
Thank you. So, do you have any questions? So questions are coming like, how to deal with the open source licenses?
How to deal with the
open source licenses?
Okay, open source license is something which you need to be very careful about in two ways. One is if your employees are generating it and developing a code. See, there are three scenarios on this. One is you are developing something for your client, and the client expects that you to write original code and give it to them. Your employees are too smart that they know that these codes are available on net, and they download it, they use open source libraries and then create the code and give it to the client. Now the client is too big. They have their own tools now to identify publicly available codes, and then they will do a testing on that. There are tools available. The client is not too smart or not too tech savvy. They may not even know. Now the problem comes when the contract says that the deliverable should be originally written by you, and the deliverable should not be infringing somebody else's IP, and you have used a third-party IP into it and given it as your IP to the client, then obviously you are answerable, even if your employee has done it. So it is for you to see that your systems in the company is in a way where your employee doesn't become too smart of downloading some publicly available code and then using it and then giving it to the client. Second thing is that with most of the services companies, your contract with most of the services companies will say that whatever you deliver under the services contract belongs to that particular client. Now, say for company A, you have agreed that this deliverable belongs to you, and the employee who was working in the company A project is posted to company C project. Now, there also you, as a company, has agreed that the deliverable belongs to the C. So the employee sees that, okay, why is he posted in C? Because the project is similar. He has an experience. You know that you actually want to make use of him. Now he is too smart that he remembers that there is a particular code that I have written for this company A, which is lying in my local machine, and that can be used for him also with some tweaking. Now he takes that, uses it in this system, and then gives it to him. So you have given it as his code, you have given it as his code also. Company A and C. Company A and C realizes that after some time that they are using the same code. What do? They come to you. What will you do? You have nothing to do rather than raising your hands. So becomes a big problem. Now, when it comes to open source, this can include open source is slightly more complicated than what I explained now. Open source there are multiple types of open source courses. It is impossible to tell you what all conditions open source has. Open source doesn't mean that it is not it doesn't have a copyright and it is completely free. The free is not on commercials. The free is on freedom to use. Okay, it is a freedom to use. That is a free software. Now, freedom to use comes with a lot of obligations. Say, for example, you take GNU GPL licenses. It has strict conditions that you are not supposed to obligate. You're supposed to give back to the community. Now, you take a GNU GPL license. Your employee takes a GNU GPL license. Modify the code. Give it in a proprietary software. You're doing two things wrong. One is you're not giving it back to the community. Second, most of the GNU GPL licenses, there is something called a contamination. Contamination is nothing but you use a GNU GPL license proprietary code with the proprietary code. Your proprietary code becomes subject to the conditions of GNU GPL, which means that the proprietary code becomes an open source license, where you have given a client a code which says that it belongs to him, where he is supposed to use it as a proprietary code, where he has paid you money for that. You have clubbed it with GNU GPL license program, given it to the client, and made it a open source software. There is nothing much for you to think afterwards. You can just raise your hands and say, I am sorry, and then face the consequences.
So, Nananji, we have 5 more questions. So before that, Alan from Airmeet wants to interact with you. He has already raised the hand. So Arya, please connect Alan to interact with. Yeah.
Am I audible?
Yes, Alan.
Hi, Mr. John. Thank you so much, Arya, for letting me on the stage. Great session, sir. On a lighter note, I have 2 questions. So I'm a big fan of this series called Suits, right? And I just want to know who is the best closer according to you in India?
Who's the best?
Closer.
Closer of?
Deals, maybe anything you can put in anything that like deals basically. Closer of cases.
I don't know. Are you saying that when it comes to commercial deals,
yes,
who is the best in? You mean the lawyer?
Yeah, like on a lighter note.
On a lighter note.
Yeah.
When I myself am a lawyer, you think I will suggest somebody else?
That is one thing, and another thing, I'm just genuinely curious to know. Let's say a guy finishes his JD and joined as an associate at a corporate firm. How long does it take for him to become a equity partner or a name partner?
Somebody has joined your company as an employee.
A person who has finished his JD has joined a firm. How long will it take for him to become a name partner? I'm genuinely curious to know.
Oh, you're talking about the law firm?
That's right, law firm.
Oh, that depends on a case-to-case basis. Okay, so each firm has their own model of structure of having inducting them as just as a partner, as a profit partner, and then sometimes they migrate themselves as an equity partner. So there are different models for different firms, and some firms don't even have a model. Also, they always remain as a associate or partner could be just a designation given.
Got it. It depends on the firm.
Yeah.
That's up for them. Awesome. Thank you.
So coming back to the questions we have, we will be moving fast forward. Like, do you have a package for startup companies?
KSUM actually has what KSUM has done is a wonderful job. So KSUM has identified professionals and have a data bank of professionals, I think, where with whom they have negotiated, discussed, and and have arranged at a commercial understanding for the KSUM mentored or KSUM companies. So obviously, when it is a KSUM based company, a startup, the rates agreed with KSUM applies to those kind of those companies. That's how it works. But otherwise, it's generally outside work. But as lawyers like me, who are closely associated with, it's not that me alone. I'm the only lawyer who is associated with startups. There could be many others also. But generally, people who associate with corporates and startups, they understand the position and the situation of a startup. And generally, everybody is sensitive towards startup. But that does not mean that lawyers will generally work for future promises and equity stake. So that doesn't really happen. But startup lawyers are sensitive towards the sentiments of startups.
So we have last 4 questions. Customers do claim we claim our source code. It's confusing when we design solutions.
Is that a question? Can I see that question somewhere?
It's last. It's one. Second, third, fourth. Customer do claim we claim our source code. I think it's not fully complete.
Customers claim the source code.
We claim our source code. It's confusing when we design solutions.
Absolutely. That's exactly why you need to have an understanding with the customer at the beginning itself. Very clear understanding. Who is going to have the IP right over the deliverable. Because at the end of the whole thing, it becomes very difficult for you to negotiate, and you probably may put yourself in a very, very difficult, dirty situation where you think that the code is yours and they think the code is theirs. And things will get more complicated when you have already given it to someone else saying that it's your code. However, ultimately it is decided that it is a customer's code. And so the contract should be very clear about who owns what.
So the next question is: are you familiar with YC safes? Simple agreements for future equity. Do we have alternatives that we use here?
Okay, the Y Combinator has a model which India has also adopted that's called a safe model. India has also adopted that model called convertible note. Convertible note is right now it's being used in India for recognized startup recognized by DIP. So we can use it in India, definitely.
Another interesting question asked by Srisham. Sorry to ask, just to have a clarification how to choose a lawyer. Is Vakil search good?
Okay, so that is a very good question. First, when you choose a lawyer, you should try to understand his background. Take references is the best method, from a couple of people whom you are comfortable with. Take references and see, whether this person you should be comfortable working with that person. The person could be busy, the person could have his own style and all things. So you should first of all try to understand whether you get a good feedback about this lawyer. Second, of course, your affordability is also a question. That is something which you need to work on. So be very clear in the beginning itself. So third, I would say this is under the presumption that the lawyer that you are assessing or the lawyer that you are talking to, whoever it is, understands your business, because that is more important for you as a person. Unless the lawyer understands the customer's business and it's not about no lawyer understands technology in depth. No lawyer, I can tell you, unless the person has an engineering background. but it is a process of appreciating technology, and then understands, okay, this works this way, and this is how it is. So the lawyer should understand your business, and if you are a technology company, it should be a person who is not technologically challenged and technologically averse. Person should be able to understand the technological nuances. And that is something which is very important for you, startups.
So second last question is this. For delayed payment, our advocate recommends filing civil case for recovery in Kerala. One of our directors is saying it is waste of time. Since it will take long time, we are caught between the two. What is the status in Kerala at the moment?
Okay. See, your director is wrong and right also. It is not about waste of time. What is your other option is the question. There is some money legally due to you, and you have good evidence, good proof to show that it's legally due to you. Why not take that money? Whether it's take 1 year or 2 years or 5 years, it is worth taking that risk. It's not that you have to be personally present before the court every time. The lawyer will take care of it. You just have to give right instructions, right documents, right feedback, right information to the lawyer. But the problem there could be is that when the contract is bad and the evidence is poor, and third, most important problem is that suppose you have 20 lakhs to be claimed from a customer. The customer is in India, in Kerala itself. When you have to start a civil litigation, you have to pay something called court fee. And court fee for 20 lakh is roughly 10%. So 10% of 20 lakhs is 2 lakhs, not a small amount. That is a problem. So arbitration, if it is arbitration, then you may not have to pay the court fee. Okay. So arbitration also can be expensive. There is an expense related to arbitration. Arbitration can be helpful at that point of time. Okay. But you will get this 2%, 10%, 2 lakh court fee if you succeed in the matter. So that is also there, but that takes some time. So here, if you are not really sure about getting that 20 lakhs, then it doesn't make sense to pay the 2 lakhs and then fight the matter. So when you draft your dispute resolution clauses also, see that you insist on a personal meeting with senior management before any litigation process is started. So that sometimes that actually helps you to solve issues with them.
So we are taking last question, and it's like small stakeholders, less than 5% of company file litigation against owners more than 10%.
Come again, Vishal? I didn't get you.
Can small stakeholders, less than 5% of company file litigation against owners more than 10%?
I can't recollect the exact section. There is a provision in the Companies Act, but 5% I think is too lower than the threshold for you to initiate a legal action against the other stakeholders on oppression. But I think it's 10%. There are various ways of circumventing this. There's 100 people, then you can do that. Then, if my memory is correct, it is 10% to initiate action on oppression.
So we are about to stop our session actually, but this question is very relevant actually. That's why I'm asking: is there any need to have a lawyer on monthly payment, or just get the contacts done?
I will personally, I don't suggest to have a retainer unless you have too much of work. If you have too much of work, get a good lawyer hired in-house. That is also an option. But otherwise, I personally don't encourage clients to have retainership, because it becomes a situation where a client thinks, I am paying him for nothing. Then he will be busy finding some work for the lawyer, and the lawyer also thinks that, okay, fine, then this is not, the timesheet is not going right way, and there's an, I've seen that doesn't really work well. So it's always better to work on a deal by deal basis, unless you have a regular stream of work coming in, and then say, okay, fine, this is the amount that I need to pay you. But if you have really good legal activities, it's always better to have an in-house legal counsel.
So it's time to conclude our session, and hope everyone enjoyed the session, and it was very informative to all our audience. I have seen like a lot of startup companies founders are in the attendee list, and if anyone have more questions, you may connect Advocate Nainan directly. So I have shared his LinkedIn ID and mail ID in the chat box. So thank you, Nainanji, for a wonderful session.
Thank you.
You have given all the insights regarding the contracts and what are the things which will be helpful to a startup company or a company to avoid the litigations. As we discussing regarding this webinar, you already mentioned like you need to avoid the litigation. That's why the lawyer play an important role in this corporate sector or a startup sector. So you have clearly mentioned all the things, and hope it was a very informative session to all also. So thank you, Nainanji.